In this lecture, we shall discuss the political question doctrine. The political question doctrine. Now, the reason this topic is important to be appreciated is because usually in a democracy, there are certain questions that end up in the courts. But these questions or disputes that end up in the courts, they are disputes that by the Constitution, they have been reserved for some particular elected branches of government for resolution. They have been committed to some particular elected branches of government for resolution. So when such issues come up before the courts, the question is that can the courts decide to adjudicate upon the matter when the court knows very well that such a matter is one that by the constitutional process has been committed to a particular elected branch of government for same to be resolved. This is what brings to birth the constitution, the political question doctrine. Now, in some democracies, especially in the United States of America, this doctrine of political question has developed. It has been developed in the United States, and its essence is that when it comes out that there is a dispute which, by virtue of the constitutional text, it has been confined to a particular elected branch of government for resolution, then such questions are non-justiciable. Non-justiciable, and therefore the judiciary is required to abstain from deciding them. Because if the judiciary decides to decide them, then that would amount to intruding upon the functions of the elected branch of government. So when it comes to bear that there is a dispute before the court, and that dispute is one that has been constitutionally committed to an elected branch of government for resolution, then such a dispute will be deemed to be non-justiciable, and it will require the judiciary to abstain and refrain from deciding those issues, as deciding those issues would amount to intruding upon the functions of the elected branches of government. The underlying philosophy behind the political question doctrine is that the resolution of such disputes must find resolution in the political process. It must find resolution in the political process because the elected branch that has been given the constitutional mandate, the constitutional power to resolve that dispute, must use its elected branch to resolve the disputes. In this lecture, I'll first of all examine how the political question doctrine has developed from the United States of America. After I have given the brief history of the political question doctrine, I will demonstrate how it's been applied in a number of cases in the United States of America. Having dealt with that, I shall then proceed to expand and expatiate on how the political question doctrine has also been applied in the Republic of Ghana. In the Republic of Ghana. Now, in the Republic of Ghana, after we have dealt with how it's been applied in Ghana, we shall identify whether there is a united front in the applicability of the political question doctrine in Ghana, or whether there is a divided or varied means of its application in Ghana. So we shall begin with a discussion on the history of the political question doctrine. And as I mentioned, we will demonstrate that it developed in the United States of America. Now, the political question doctrine in its development in the United States of America was first enunciated and laid down in the case of Marbury and Madison. Marbury and Madison. Now, in Marbury and Madison, the Supreme Court of America held that the principle of separation of powers has the effect of making certain non-justiciable questions. It has the effect of making certain questions non-justiciable, because by making such questions non-justiciable, it achieves the purpose of preventing one organ of government, especially the judiciary, from intruding on the powers of the political branches of government. In fact, in Marbury and Madison, the court expressly noted, and I quote, that it is emphatically the province of the judicial department to say what the law is. And the quote ends. Now, when the court is saying that the power of the judiciary is to lay down what the law is, it means that it's not the power of the judiciary to be interfering in responsibilities of elected branches of government. Now, in Marbury and Madison, even though the courts recognize that it is the power of the judiciary to lay down and state what the law is, they noted as follows, and I quote once again. I'm quoting now from Marbury and Madison. The Supreme Court noted that the province of the court is solely to decide on the rights of individuals, not to inquire into how the executive or executive officers perform duties in which they have discretion. Questions in their nature political, or which are by the Constitution and laws submitted to the executive, can never be made in this court. I'll take the quote once again. The province of the court is solely to decide on the rights of individuals and not to inquire how the executive or executive officers perform duties in which they have discretion. Questions in their nature political, or which are by the Constitution and laws submitted to the executive, can never be made in this court. So what can be gleaned from the dictum of Chief Justice Marshall in Marbury and Madison is that the Supreme Court is realizing that there are some questions that may be legal. And if those questions are legal, those questions the judiciary can pronounce on those issues. And there are also questions that may be political. And if such questions are political, then it is the political process, the political branches that must be allowed to deal with such issues. Because the Supreme Court noted, and I quote once again, that questions in their nature political, or which are by the Constitution and laws submitted to the executive, can never be made in this court. So if the question is a political one, then that one, it must be resolved by that elected branch of government, if it's the executive. If the question is a legal one, that one, it can be resolved in the courts. It is for this reason that a lot of commentators have argued that the political question doctrine is an offshoot of separation of powers, because embedded in the political question doctrine is the assignment of responsibility for interpreting the laws to the judiciary. And also the judiciary recognizing that there are some questions that are constitutional that must be resolved by only the executive. So that is how it's been indicated that the political question doctrine developed in the United States in the case of Marbury and Madison. But let me mention that ever since it developed in Marbury and Madison, the Supreme Court, still in the United States, has had the opportunity to apply the political question doctrine in a number of cases. One of such cases is the case of Baker versus Carr. Baker is spelled B-A-K-E-R versus Carr, C-A-R-R. Citation 369 U.S. 186 into bracket 1962. In the case of Baker and Carr, Justice Brennan is spelled B-R-E-N-N-A-N, Justice Brennan. He wrote for the majority in Baker and Carr, and then he announced 6 criteria. He announced 6 criteria for assessing when a case may be dismissed under the political question doctrine. He announced 6 criteria for assessing when a case may be dismissed under the political question doctrine. And the criteria are as follows. 1, the textually demonstrable constitutional commitment of the issue to a coordinate political department. Textually demonstrable constitutional commitment of the issue to a coordinate political department. What he's saying over here is that if you can tell that textually the Constitution has committed that particular issue to a coordinate political department, then it is that political department alone that must be allowed to resolve that particular issue, and the court is not supposed to interfere in such responsibilities. So Justice Brennan is saying that 1, when you can dismiss a case under the political question doctrine. In other words, when a case comes before the courts, they can hold that the case is non-justiciable when 1, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department. That is number 1. Or number 2, you can also dismiss a case as being a non-justiciable political question when there's a lack of judicially discoverable and manageable standard for resolving it. When there's a lack of judicially discoverable and manageable standard for resolving it. So what Justice Brennan is saying over here is that if you have a question before the court, and this question, you the judge, you can tell that there's no judicially discoverable means or standard for resolving it, then it means that that question, you don't have any judicially discoverable means because it is not for you, the judiciary. You must allow that particular elected organ of that means who has been given the mandate to resolve it. So Justice Brennan is saying as a second point that when there is a lack of judicially discoverable and manageable standard for resolving it, then it's a political question. Justice Brennan goes ahead to note as follows, given as a third criteria. He says that you can dismiss a case on the ground that it is a non-justiciable political question when you can tell that there is an impossibility of deciding that issue without an initial policy determination of a kind clearly for non-judicial discretion. When there's the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. It means that if you are a judge and then you have a case and you can tell that determining this case would require you to make an initial policy determination. And that policy determination, you don't have any judicial discretion to make that policy determination. It means that that is a matter that you, the judge, you don't have any judicial discretion to make that initial policy determination. Then it means it's non-justiciable, and you must allow that elected organ of government to deal with the matter. Then I'll just list the other three criteria that Justice Brennan gave. Number 4, when there's an impossibility of a court's undertaking independent resolution without expressing lack of respect, due coordinate branches of government. Or number 5, where there's an unusual need for unquestioning adherence to a political question, a political decision already made, where there's an unusual need for unquestioning adherence to a political decision already made. Or number 6, where there's the potentiality of embarrassment from multifarious pronouncements by various departments on one question. So Justice Brennan has given any of these, that if you can tell that any of these is sufficient, any of this is present, any of the 6 are mentioned. For example, if you can tell that there is a constitutional commitment of the issue to a coordinate branch of a political department, then please, the judiciary, that question is a non-justiciable political question, and you don't have any business in interfering in such a matter. Or when, as a judiciary, you can tell that there is no judicially discoverable means or standard for resolving it, then allow the particular organ of government that has been elected to resolve it. It's a non-justiciable political question. So if any of these are present, then you can tell that the question is a political question which is non-justiciable, and the courts must not interfere in the responsibilities and functions of that organ of government that has been given the constitutional mandate to deal with that particular issue. So after he has listed this criteria, Justice Brennan then notes that the whole purpose and benefit of the political question doctrine, and this is Justice Brennan in the case of Baker and Carr. After he has listed the criteria for determining when something will qualify as a non-justiciable political question, Justice Brennan goes ahead to note that the whole purpose of the political question doctrine is to preserve the separation of powers, and then to minimize claims by other organs of government that would undermine that separation of powers principle. And then even if you look at the case of Koohi, K-O-O-H-I, versus the United States. Koohi versus the United States. K-O-O-H-I versus the United States. In fact, the court even noted, some members of the United States Federal Bench even went ahead to suggest that the political question doctrine serves a purpose of preventing the federal courts from engaging in an undue intrusion on certain policy choices and judgments that have been constitutionally committed to the United States Congress or to the executive branch. So, we are being told by some members of the United States Federal Bench, in the case of Koohi versus the United States, that the essence and purpose of the political question doctrine are that it prevents federal courts from unduly intruding on certain policy choices and judgments that are constitutionally committed to the United States Congress or the executive branch. Another case in which the political question doctrine has been applied in the United States is the case of Nixon versus the United States. Nixon versus the United States. In this case, the court noted and held that the impeachment of a judge was a political question and therefore non-justiciable. The impeachment of a judge was a political question and therefore non-justiciable. So at this point, what we have done so far is to examine how the political question doctrine developed in the United States in the case of Marbury and Madison. We have seen how Justice Brennan applied and gave a criteria for determining the existence of a political question doctrine in the case of Baker and Carr. And now we have seen how it's been also applied again in the United States in the case of Nixon versus the United States. So 3 cases so far for the United States: Marbury and Madison, Baker and Carr, and then Nixon and United States. If you want an extra case for that, you can look at the case of Gillian and Morgan, Gillian versus Morgan. That will be enough for how the doctrine has been applied in the United States. Now let's come to Ghana. In Ghana, the first case we shall examine is the case of New Patriotic Party versus the Attorney General. New Patriotic Party versus the Attorney General. What we all know as the 31st December case. This is reported in the 1993-94 2 Ghana law report at page 35. In this case, the government was taking steps to declare 31st December as a national holiday. And then the New Patriotic Party challenged the action in the Supreme Court. The basis of the challenge was that the intended celebration of 31st December, which was a day on which a coup d'etat was staged in Ghana. It was a day in which a Republican constitution was overthrown. According to the New Patriotic Party, that day, which was a day of a coup d'etat, that you are seeking to celebrate that coup d'etat, according to the New Patriotic Party, the intended celebration violates the letter and spirit of the 1992 Constitution. And therefore, they brought an action under Article 2 of the Constitution, seeking to enforce the supremacy of the 1992 Constitution. That since the 1992 Constitution frowns on coup d'etats, then you cannot use state funds to celebrate such a holiday. Now, when the matter came before the Supreme Court, the Attorney General put forward multiple defenses. One defense was that the declaration of holidays was a political question that has been given to the executive by the Constitution. And it's true. Under the Constitution, who has the power to declare holidays? It's the executive. So the government invoked the political question doctrine and argued that since the Constitution has given the power of declaring holidays to the executive, then a determination of that question was a political question for the executive to decide. And it was not a business for the courts to decide for the country which day should be declared as a holiday and which day should not. Therefore, the government argued that whether or not 31st December should be declared as a public holiday, it was a non-justiciable political question for the executive to decide. Now, this case was decided by a 5-4 majority decision. That should tell you that the case was keenly contested. Now, one of the judges who wrote for the majority, he rejected the applicability of the political question doctrine in Ghana. Justice Adade, he rejected the government's arguments. Adade argued that the political question doctrine that developed in the USA was not applicable in Ghana. According to Justice Adade, the whole Constitution of Ghana is a political document, and any matter that may arise for it to be interpreted may be political or may have some political dimension. And that cannot be the basis for depriving the Supreme Court of the power of enforcing the supremacy of the Constitution. So what Adade was saying is that at the end of the day, what they have the responsibility to do as judges is to enforce the supremacy of the Constitution. So if a question comes before them and they are going to enforce the Constitution, the fact that it is going to violate the political question doctrine is inconsequential, because their duty as judges under Article 2 and Article 130 of the Constitution is to enforce the supremacy of the 1992 Constitution. And let me quote some portions of Justice Adade's judgment so that you can understand how Adade rejected the political question doctrine in Ghana. Adade says as follows, and I quote, the conclusion is inescapable that in this country we have no doctrine of political question such as exists in the United States. What we have is a written constitution, 1992, to be interpreted and enforced, with the result that in Ghana, courts and tribunals, much lower in the hierarchy than the Supreme Court, may lawfully decide cases which may involve political questions. In further reaction to the defendant's argument that the issue is a political one, it must be understood that the Constitution 1992 itself is essentially a political document. Almost every matter of interpretation or enforcement which may arise from it is bound to be political, or at least to have a political dimension. Then he goes ahead to say, and I quote, I must say that in spite of these carefully woven constitutional provisions and safeguards, democracy could not be protected. As we all witnessed on 13 January 1972, the point, however, remains that provisions relating to the protection of the Constitution 1992 and the defense of democracy are by their nature political. And these provisions, this court is by the Constitution 1992 required to interpret and enforce. Therefore, to refuse to do a constitutional case on the ground that it is political is to abdicate our responsibilities under the Constitution 1992 and to breach in particular Articles 2 and 3 thereof. Thus, the invitation to decline jurisdiction on account is an invitation to this court to act unconstitutionally, which invitation must itself be unconstitutional, as it cannot be subversive of the Constitution. I must reject that invitation. Therefore, Adade rejected the invitation to apply the political question in Ghana. According to him, what is applicable in Ghana is constitutional supremacy. What he knows is the constitutional supremacy. Justice Amasechi, who also wrote a concurring opinion for the majority, also took the view and held in relation to the political question at page 34 of the report as follows. At page 131 of the report, 130 and 131 of the report as follows, and I quote, it was also said that the issue is a political one and that the plaintiff ought to have its complaints to Parliament. Perhaps, if it had been represented in Parliament, it might have sought an amendment or repeal of the offending legislation. However, there was nothing to stop it making a legal issue of it and coming to this court for redress. Parliament now has no uncontrolled right to pass laws on public holidays, any more than it has to declare a one-party state or make leader president for life or crown him emperor. As the fundamental or basic law of the Constitution, 1992, controls all legislation and determines their validity. It is for the courts, as the guardians of legality, to ensure that all agencies of the state keep within their lawful bounds And the quote ends. Again, he says that as the fundamental or basic law, the Constitution, 1992, controls all legislation and determines their validity. It is for the courts, as the guardians of legality, to ensure that all agencies of the state keep within their lawful bounds. He also has recognized that the plaintiff has framed his case as a legal one, and nothing stops the plaintiff from raising the issue as a legal point and coming to the court for redress. Because at the end of the day, what the defendant is doing is seeking to declare a holiday. And if you are declaring a holiday on a day that the plaintiff thinks frowns, it's an affront to the Constitution, the plaintiff has a right to bring an action to enforce the supremacy of the Constitution. And when he frames the action as a legal one, seeking to enforce the supremacy of the Constitution, it will not lie in your mouth as a defendant to say that let us rather go to Parliament to have it resolved. You can go to Parliament to have it resolved, but they also have a right to come to court because it's also a legal issue. And once they have come to the court for the legal issue, the court must enforce the supremacy of the Constitution. So Amoah Setri also rejected the applicability of the political question doctrine in Ghana. What Amoah Setri was essentially saying was that the powers of the Supreme Court were broad enough and can cover legal questions and can also cover political questions, so long as you can frame the political questions as legal ones and come before the courts. However, let me mention that even though the majority position was that the political question doctrine was not applicable in Ghana, we had members of the minority who were part of the foreign minority who also took the view that the political question doctrine was applicable in Ghana. Let me just take you to two of such positions. First is the dictum of Mrs. Joyce Bamford Adu. Mrs. Justice Joyce Bamford Adu. And this is what she said at page 155 of the report. She says that it is not for the judiciary to formulate public policy issues, but for the executive or the legislature, and we cannot usurp their function, either directly or indirectly. And the quote ends. She also says at page 153 of the report as follows, and I quote, "It can be seen that the fixing of a date for celebration as a public holiday is a policy decision of the government, an executive act, and can be changed whenever that or any other government deems it expedient to do so by legislation. It seems to me, therefore, that the 31st December public holiday, unless unconstitutional, which I have said it is not, can only be deleted from the list of public holidays by any government which desires this as a policy decision to take the necessary legislative action to delete this date from the list provided in PND's Law 220. Quote ends. So what Mrs. Justice Bamford Adu in saying is that the political question doctrine is supposed to be applicable because the powers of the courts do not extend to declaring which days are supposed to be holidays and which days are not supposed to be holidays. Again, let us also look at Justice Archer, also in the minority. This is what Justice Archer also says. Justice Archer also recognized that the political question doctrine was applicable in Ghana. He affirmed the position that the court is not supposed to poke its nose into how the executive and parliament goes about its business. And this is what Justice Archer says at page 52 of the report. Remember, he was in the minority. He was in the minority. And this is what he says, and I quote, "I have quoted this article," and the article in reference to Article 108. "I have quoted this article in extenso to demonstrate the procedure the Constitution, 1992, has laid down for the provision of monies for the government to administer the country. It is only the president, who is the head of the executive, who can go to parliament to seek financial provision, charged upon the consolidated fund. Nowhere in this article is the role of the judiciary mentioned. Yet, this court is being invited to prevent the government from spending monies which Parliament has constitutionally provided for government use. I think if the order is granted, it would amount to judicial officiousness, poking our noses into the affairs of Parliament and intermeddling with the prerogative of the executive by directing the government not to spend monies approved by Parliament. Such a move clearly amounts to a violation of the doctrine of separation of powers, which is the core of our Constitution, 1992. These are the words of Justice Archer. So we can tell from all of these that even though Adade, Amasechi, and the others who were in the majority have held that the political question doctrine was not applicable in Ghana, and that what is applicable in Ghana is the supremacy of the Constitution, we have also seen that some members of the minority, like Bamford Adu and Justice Archer, also took the view that the political question doctrine was applicable in Ghana. But remember, it's the majority that carries the day. So the majority position in the 31st December case is that the political question doctrine is not applicable in Ghana, and that what is applicable is constitutional supremacy, and that the courts are bound to enforce the supremacy of the Constitution. The supremacy of the Constitution. Remember that in the 31st December case, it has been held that the political question doctrine is not applicable in Ghana. That's the case of New Patriotic Party versus Attorney General, 31st December case. We shall move on to the next case. That is the case of Ghana Bar Association versus Attorney General. Ghana Bar Association versus Attorney General. This is reported in 1995-96, One Ghana Law Report at page 598. Now, in order to set this case in a very good perspective, it is good that I read Article 144 of the Constitution out. Article 144 clause 1 reads as follows: that the Chief Justice shall be appointed by the President, acting in consultation with the Council of States and with the approval of Parliament. The Chief Justice shall be appointed by the President, acting in consultation with the Council of States and with the approval of Parliament. Another article that we must also note before I delve into the facts of Ghana Bar Association and Attorney General. The next article is Article 146 of the 1992 Constitution. Article 146 gives the procedure for removing a justice of the Superior Court from office. So if a person wants to remove the Chief Justice from office, by the dictates of Article 146, the person must first send a petition to the President. Then if he sent the petition to the President, then the President, on the authority of Adjechum, would have to consult with the Council of States and then determine whether there is a prima facie case. When the Council of States then determines whether there's a prima facie case, that is when a committee will now be formed to probe for the removal or whether there are sufficient grounds for the removal of the CJ or not. All I'm saying is that there's a procedure that is laid down under 146 for the removal of the Chief Justice, and it begins with sending a petition to the President. Now, the fact of Ghana Bar Association and Attorney General. Now, in this case, the President of Ghana, acting pursuant to the dictate of the Constitution, under Article 91 and under Article 144 of the Constitution, he nominated the Chief Justice. He nominated Justice Aban as the Chief Justice for approval by Parliament. Now, Aban went to Parliament and Parliament approved of his nomination. So when Parliament approved of his nomination, then Justice Aban became the Chief Justice. Now, the Ghana Bar Association objected to the appointment. In fact, they vehemently opposed the appointment and they brought an action to the Supreme Court. The essence of the action, the crux of their action, the government of their suit was that Justice Aban, according to the Ghana Bar Association, was not a person of high moral character and proven integrity, and therefore he was not a person who was qualified to be appointed as Chief Justice. They said he was not appointable as Chief Justice. They therefore sought a declaration that the appointment of Justice Aban by the President as Chief Justice, as well as the advice of the Council of States and the approval of Parliament of the nomination, was unconstitutional. That must be a very bold case. You are saying that even though the President has appointed Aban as Chief Justice, according to Article 144, he has been sworn into office, he has been approved by Parliament. You are saying that the appointment is, in fact, you are saying the appointment, the advice of the Council of States, and even the approval of Parliament, everything over there is unconstitutional. So Aban should not be the Chief Justice. But one thing you should remember in this case was that at the time Aban was appointed as Chief Justice, he was already a Justice of the Supreme Court. He was a Justice of the Superior Court before he was appointed. That's what you should note. He was the Justice of the Superior Court already. Now they have appointed him as Chief Justice, Parliament has approved, Council of State has been consulted, and you are saying that no, the nomination and appointment by the President, the approval by Parliament, and advice of the Council of State, everything is unconstitutional. Now, the Attorney General raised an objection. The essence of the objection was that when it comes to appointing a Chief Justice, it was a non-justiciable political question, which by the dictates of the Constitution has been specifically committed to the President, the Council of State, and Parliament. The Attorney General argued that by the political question doctrine and by the virtue of the principle of separation of powers, the appointment of the Chief Justice, it was a non-justiciable political question that was specifically committed to the President, committed to the Council of State, and committed to Parliament. And therefore, it was non-justiciable in the courts. That was the objection by the Attorney General. And what was the holding of the courts? Justice Pega, he wrote for the majority, and he held that the political question doctrine was applicable in Ghana. Justice Pega at page 642 of the report said as follows, and I quote, and he was referring to the dictum of Adade GSA in the case of the 31st December case. And this is what Pega GSA said, and I quote, before proceeding any further, I would like to take a look at the view of Adade GSA in the 31st December case, that even in the United States, the doctrine of political question does not apply to the United States Supreme Court, the ultimate interpreter of the Constitution. I do not think this, so the quote ends. So Adade GSA now goes ahead to say as follows. I do not think this is a correct statement of the authorities on the point. At the Baker case, which Adade relied on for his views, itself demonstrates it being a decision of the United States Supreme Court. Justice Brennan in that case stated the ingredients of the political question doctrine, which he said he distilled from cases in which the principle was held to be applicable. However, in the particular circumstance of the Baker case, the majority held the view that the criteria was not reached. Baker then goes ahead to quote what Adade said. So this is what Adade said at page 65 of the report. Adade said, and I quote, therefore, to refuse to do a constitutional case on the ground that it is political is to abdicate our responsibilities under the Constitution and to breach in particular Articles 2 and 3 thereof. So Adade was saying that, you remember Adade, the first December case, that if they refuse to adjudicate upon the case, they'll be abdicating their responsibilities under the Constitution. So they'd rather go ahead and affirm the supremacy of the Constitution. How did Pega answer that in Ghana Bar Association? Pega said as follows, and I quote, and this is Pega in Ghana Bar Association versus Attorney General. And this is what Pega said. With great respect to my learned brother, and by learned brother, he's referring to Adabi. With great respect to my learned brother, I think this is a very simplistic way to consider a serious and deep legal concept, like the political question. I have always been of the view that the principle of political question is something which is inherent in the concept of separation of powers, where certain functions are committed to a specific branch of government. In such a situation, a political question cannot evolve into a judicial question. Goes ahead to say as follows, that to demonstrate that the principle of non-justiciable political question is the product of separation of powers, I'll refer to some judicial opinions. Then Pega goes ahead to refer to Baker and Carr and shows how the political question doctrine was applied in that particular case. And then he goes ahead to now conclude as follows. I'm quoting from Pega JSC in Ghana Bar Association and Attorney General. This is what Pega JSC says. The Ghanaian Constitution, 1992, has been influenced not only by our past experiences, but also by thinkers like Montesquieu in the allocation of state power to the three branches of government: the executive, legislature, and the judiciary. The adoption of the concept of separation of powers by the framers of our Constitution, 1992, aims not only at the prevention of the exercise of arbitrary power with its attendant tyranny, but also aims at the promotion of efficiency and avoidance of friction or conflict between the various arms of government. See the case of Tufo and Attorney General, where the Court of Appeal sitting at the Supreme Court declined jurisdiction to examine proceedings in Parliament and consequently struck out the Speaker of Parliament as first defendant. And in the case of Youngstown Sheet and Tube Company versus Sawyer, steel seizure case, Justice Jackson said of the concept of separation of powers, while, and I quote, while the Constitution diffuses power the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity, and the quote ends. Justice Pega went ahead to deliver himself as follows, and I quote, there are local judicial statements against the view of Adade JSC expressed in New Patriotic Party versus Attorney General. The celebrated case of Tufo and Attorney General offers the first example. In this case, one of the reliefs the plaintiff was claiming was a declaration that, and I quote, the purported nomination by the President of the Republic of Fred Kwesi Appalu for approval by Parliament of his appointment as Chief Justice of the Republic and member of the Supreme Court, and his purported vetting and rejection by Parliament as such on 16 August 1980, were each acts effected in contravention of the Constitution and the laws of the Republic, and were therefore null and void and of no effect. The quote from Tufo and Attorney General ends over there. Pega JSC continues as follows. Still in the case of Ghana Bar Association and Attorney General, Pega JSC goes ahead as follows, and I quote, the Speaker of Parliament was made first defendant in this suit, that's the suit of Tufo and Attorney General. The court considered the impropriety of joining the Speaker of Parliament and decided to strike out the Speaker as a defendant. This is what the court said at page 650, and I quote. I'm quoting from Tufo and Attorney General at page 650 of the report. This then brings us to the question of how far the court can question what under our Constitution has been done in and by Parliament. There is a long line of authorities which establish two important principles governing the relationship that should subsist or should exist between Parliament and the courts. A, that the court can call in question a decision of Parliament. but the court cannot seek to extend their writs into what happens in Parliament. And B, that the law and custom of Parliament is a distinct body of law, as constitutional experts do not put it, unknown to the courts. The court continued that at the same page as follows, and I'm quoting, and this quote is still, Pega is quoting from Tuffuor Attorney General, and this is what the quote says. The courts take judicial notice of what happened in Parliament. The courts do not and cannot inquire into how Parliament went about its business. These constitute the state of affairs as between the legislature and the judiciary, which have been crystallized in Articles 96, 97, 98, 99, 103, and 104 of the Constitution. Of particular importance to us are the provisions of Article 96 of the Constitution. They confer on Parliament freedom of speech, of debate, and of proceedings in Parliament. The article also states categorically that freedom shall not be impeached or questioned in any court or placed out of Parliament. In Tuffuor Attorney General, the court went ahead at page 650 to 651 as follows, and I quote, "The court cannot therefore inquire into the legality or illegality of what happened in Parliament. Insofar as Parliament acted by virtue of the powers conferred upon it by the provisions of Article 91, its actions within Parliament are a closed book." And then the quote ends. So that is the quote from Tuffuor Attorney General. And now I'm coming back to what Pega JSC said about the Tuffuor Attorney General case. What Pega JSC said about that in the Ghana Bar Association and Attorney General. This is what Pega JSC said. The rationale for the court's holding that proceedings in Parliament are a closed book and cannot be subjected to judicial review is the concept of separation of powers and its necessary implication of non-justiciability of proceedings in Parliament. This case is a classic example of a court being confronted with a complex issue of constitutional interpretation, a function of the Supreme Court, to give itself jurisdiction in the strict sense, and yet applying the same time the principle of a non-justiciable political question to decline jurisdiction to go into an issue. Full stop. Now, what do we get from here? What we get from here is that in the Ghana Bar Association and Attorney General case, Pega JSC is saying that the political question doctrine is applicable in Ghana. That's number one. And he's not only saying that, he's saying that it is that same political question doctrine that was applied in the Tuffuor Attorney General case, when the court decided that they will strike out the Speaker of Parliament as a party, and therefore they will not go into what goes on in Parliament, because whatever goes on in Parliament is a closed book. So we realize that for many of you, when you read Tuffuor Attorney General, you may not have realized that what they were applying over there was a political question doctrine. But Pega JSC in Ghana Bar Association and Attorney General is telling us that the political question doctrine is applicable in Ghana, and that the judges were wrong when they held in the 31st December case that the political question doctrine was not applicable in Ghana. And Pega went ahead to also demonstrate that it is that same political question doctrine that was even applied in Tuffuor Attorney General, when the Speaker of Parliament was struck out as a party, and the court held that they will not poke their nose into what goes on in Parliament. So one would be asking, so what was the holding in the case of Ghana Bar Association Attorney General? To refresh your memory, that was the case where the Ghana Bar Association were challenging the appointment of Aban as Chief Justice. And they were saying that the appointment was unconstitutional. Remember that under Article 144 is the Chief Justice that has the power to do the appointment. And that is why the AG made an objection that when it comes to the appointment of the Chief Justice, it was a political question for the court to decide, and not for, it was a political question for the executive to decide, and not for the courts. And what did the court hold? The court agreed with the Attorney General that when it comes to appointing the Chief Justice, under Article 144, it was the power that was reserved for the president. And the court cannot decide for the president who they should appoint as Chief Justice and who they should not appoint. The court wanted to know that if it is your case that Abba was not qualified to be a Chief Justice, then your proper remedy was under Article 146, which was a procedure for removing a Justice of the Superior Court from office. So you must go and use that procedure rather under Article 146 to remove him. But you can't come and hide and rather let the court determine who should be appointed as Chief Justice and who should not be appointed, when that is a political question that has been reserved for the executive under Article 144 of the Constitution. God criticized the dictum of Adade GSA in the 31st December case. So the question now is that we have 31st December case saying political question doctrine is not applicable in Ghana. Supreme Court of Ghana. Then we have Ghana Bar Association Attorney General, where they are being told that the political question doctrine is applicable in Ghana. Still Supreme Court. So now what do we do? Which one will take precedence over the other? Let us look at the case of J.H. Mensah and Attorney General. J.H. Mensah and Attorney General reported in 1997-98, One Ghana Law Report at page 227. Let's have a look at that case and see whether it will assist us in identifying whether the political question doctrine is applicable in Ghana. Now, this was a case which came about because after President Rawlings won the election again in 1997, he was supposed to be sworn in as president. After he was sworn in, he indicated and announced that some of the people that he had used as ministers in his first government, that is from 93 to 96, some of such ministers will be retained. And if they are going to be retained, he noted that under Article 78, whenever he appoints his ministers, he must take them to Parliament for approval. But he mentioned that since he's going to retain some of the ministers who have already gained the approval of Parliament, he will not take them to Parliament again for any form of approval. So this decision is what led to the action to be commenced at the Supreme Court for a declaration that by the interpretation of Article 78, the president must take all his ministers to Parliament for approval. Of course, the Attorney General raised an objection that when it comes to the appointment of ministers, it was the prerogative of the executive. It was a political question for the executive, which could not be questioned by the courts. And what did the courts say? Justice Akwa said as follows, and I quote, "If by the political question doctrine, it is meant that where the Constitution allocates power or function to an authority, and that authority exercises that power within the parameters of that provision and the Constitution as a whole, a court has no jurisdiction to interfere with the exercise of that function, then I entirely agree that the doctrine applies in our constitutional jurisprudence. But this is what is implied in the concept of separation of powers. But if by the doctrine, it is meant that even when the authority exercises that power in violation of the constitutional provision, a court has no jurisdiction to interfere because it is the Constitution which allocated that power to the authority, then I emphatically disagree." Quote ends. So what Justice Akwa is saying is that, well, for he doesn't have a problem. If your application of the political question doctrine is going to result in conforming with the Constitution, then he doesn't have a problem. He says that if by the political question doctrine, what is meant is that if the authority is exercising his power within the parameters and the court has no jurisdiction, then he agrees. But if by political question doctrine, what you mean is that even if that institution is breaching the Constitution, then the court cannot interfere, and that one he disagrees because he recognizes that over there they must inform the supremacy of the Constitution. This is what Akwa says in J. Mensah and Attorney General. To read the full case, to get the full import of his statement and how the court came to the conclusion in the case. And the court held that as far as the appointment of ministers is concerned, anytime you appoint a minister, the court interpreted Article 78 to mean that you must always take them to Parliament for prior approval. But Akwa's dictum about the political question doctrine is very, very key. Now, we have been able to look at the applicability of the political question doctrine in the United States. We've looked at Marbury and Madison. We've seen how it was applied in Baker and Carr, and we've seen how it arose in Nixon and United States. We've come to Ghana. We've seen how, in the case of New Patriotic Party and Attorney General, 31st December case, we are told that the whole doctrine was not applicable in Ghana. We saw how Adade said that the whole constitution is a political document and a legal document as well, and therefore, any question can be enforced in the court of law. We've seen how, in the case of Ghana Bar Association Attorney General, Kpegah JSC criticized Adade heavily and held that Adade was wrong in saying that the political question doctrine was not applicable in Ghana. And so Kpegah JSC took the view in Ghana Bar Association that the political question doctrine was applicable in Ghana. And we've seen what Akwa is saying in J. Edmondson and Attorney General, that in J. Edmondson and Attorney General, he's saying that if by political question doctrine, what you mean is that if the particular institution or organ is acting within the confines of the Constitution, the court cannot question it, then they agree it to be applicable. But if by political question doctrine, what you mean is that if that particular organ is breaching the Constitution, nobody can interfere, then Akwa says he disagrees. So Akwa's position has been referred to some scholars as the compromised political question doctrine. He wasn't bold in saying what is and what is not. Now, we have looked at these cases are all from the Supreme Court. Let me just give you two other cases that you can just read in order to elevate your consciousness about whether the political question doctrine is applicable in Ghana or not. The first case is Asari and Attorney General. Attorney General is unreported case number 21/2006, 15 September 2006. It's a case about the then Member of Parliament, Martin, who was arrested in the United States. And then when he was arrested and then he was convicted over his seat in Parliament was now in insecurity. And so the Speaker of Parliament decided Martin a dispensation to be absent from Parliament indefinitely. So when they granted him that dispensation to be absent, Asari brought an action to the Supreme Court, arguing that no, what has to be done is that his seat has to be declared vacant. His seat has to be declared vacant. And it's not that you go and say that you are rather going to grant him leave to be absent indefinitely. And what did the court hold? The court held that as to whether they will declare the seat vacant or they will grant him leave indefinitely, it was a power that was reserved for Parliament to decide. So if Parliament has decided that, the court cannot decide for Parliament how it should go about its business. Yes. So that is what Parliament, so you read the Asari and Attorney General case to get how the court addressed that particular issue. Let you see what the judge, Justice Ayabi, said. He said as follows, that it is Parliament as the legislative arm of government, which is mandated by the Constitution to determine the reasonableness or otherwise of a Martin's explanation of his absence through the Committee on Privileges. So he wanted to say that the decision of Parliament will stand the test of time, and it's a political question intra vires the Constitution, and therefore not subject to judicial scrutiny, in the quote ends. So you read that case to see how the court applied the political question doctrine in Ghana. And then you can also read the case of Amidu versus Kufuor, and see how the courts, the case is reported in 2001, 2002 Supreme Court of Ghana law reports, and over there, read the dissenting opinion of Kpegah JSC in Amidu and Kufuor. So we have gone over the political question doctrine, and I believe by now you will have a deeper insight about what the political question doctrine is. This is where we'll end our lecture on the political question doctrine.